Hello everyone. This presentation is intended to focus on the scope and importance of administrative law. Now, what is administrative law? Administrative law deals with the organization, powers, and functions of administrative and quasi-administrative agencies and consists of rules and principles which govern and review the action taken by these agencies in relation to the liberty and freedom of individuals. Administrative agencies exercise wide range of powers which affect the individuals in their day-to-day life. It includes the study of principles that have to be followed by these agencies while exercising their powers in relation to individuals. Administrative law concerns itself with official actions which may be rule making, rule decision, rule application, and ministerial. When any administrative authority exercises the lawmaking power delegated to it by the legislature, it is known as rule-making action of the administration or quasi-legislative action. When the administrative authority is required to declare rights or impose upon parties obligations affecting their civil rights, and therefore they are required to act judicially, it is a quasi-judicial action. In the case of rule application action or administrative action, the administrative authority is required to decide based on policy or on the need of the hour. It does not decide a right, though the action may affect a right. Example being granting or refusing a license. Action taken by the administrative authority as a matter of duty imposed upon it by law without any discretion or judgment is ministerial in nature. Here there is performance of a definite duty without any choice. Example being collection of taxes, duties, etc. In addition to the above, the study of administrative law also includes processes like investigation, supervision, giving advice, declaration, or prosecution. The emphasis of the study of the subject is on the procedure which has to be followed and which is followed while taking a decision by administrative authority. The study also includes the study of control mechanisms which keep the administrative agencies within bounds and scrutinize the legality or otherwise of the administrative action. These include the judicial control exercised by courts over administrative action through writ jurisdiction and through suits filed by the affected parties against the government. Grievance redressal machinery, which include the Ombudsman and Human Rights Commission, etc., are also entrusted with the responsibility of checking abuse of power by administrative authorities. Parliamentary control is exercised through laying the rules and regulations on the table of the House of the Parliament for scrutiny and scrutiny by the Committee on Subordinate Legislation. In addition, right to information, right to representation, easy access to justice, etc., are the rights available to the citizens to raise their voice against abuse of power by the administrative authorities. Reconciling power with liberty, growth with justice, and free competition with fair competition form the focal points of study of administrative law. Principles of administrative law come to the rescue of an ordinary citizen whenever and wherever he is victimized by the arbitrary exercise of power by the public authorities. Now, why has the scope of administrative law expanded so drastically? In the beginning, the state was only a police state which was mainly concerned with protection from external aggression and maintenance of internal order. From there, it moved on to paternalism, wherein it was concerned with securing the welfare of the citizens also. But today, the state's role has transformed from paternalism to materialism, where consumer goods and services provide the greatest source of satisfaction in the life of human beings. In addition, due to globalization, people started looking upon the government as an enabler, facilitator, and regulator rather than as a provider. The government today has not only to perform the functions of protecting the state from external aggression and maintenance of law and order internally, but also take care of the people from cradle to grave, and hence the administrative processes increased and administrative law gained a lot of significance. We have seen that administrative agencies perform quasi-legislative, administrative and quasi-judicial functions. There has been a drastic increase in all these functions. Why? Due to liberalization and privatization, there has been an erratic production and distribution of wealth and concentration of economic power in hands of few. This warranted an increase in administrative functions as there arose a need to regulate the pattern of ownership, production, and distribution of wealth in order to ensure maximum good to the maximum number. Modernization and technological developments produced massive structural changes, and this was the root cause of numerous problems like cultural conflicts, disorganized urbanization, erratic exploitation of natural resources, environmental pollution, etc. Now, dismal health, education, employment, and training conditions, labor strikes, and lockouts caused a lot of dissatisfaction among people. Socio-economic offenses like corruption, adulteration, tax evasion, and smuggling have been on the rise. All these further led to the growth of administrative agencies and laws regulating them. Similarly, inadequacy in the type of courts that exist to give quality and quantity of performance in this century led to growth of administrative adjudicatory agencies. There has been an increase in the administrative legislative processes also, as the traditional legislatures are not in a position to deliver the quality and quantity of laws required in these modern times. This is because of paucity of time, lack of expertise, flexibility, and want of tendency to experiment and take quick action in emergent situations by the legislature. Because of liberalization, globalization, and privatization, there has been an expansion of global administrative space. The intergovernmental regulations like the General Agreement on Trade and Tariff, that is GATT, TRIPS, that is Trade Related Intellectual Property Rights, TRIMS, that is Trade Related Investment Measures, by global agencies like the World Trade Organization, World Bank, and the International Monetary Fund have an impact on the national scenario, and hence there is a need to approach the study of administrative law with a global dimension in order to ensure that there is an inclusive and equitable world economic order. Hence, the administrative law becomes a mechanism to enforce accountability and responsibility in global governance by states as well as corporations, firms, autonomous agencies, individuals, and civil societies. Therefore, it's important as a citizen to have a fair knowledge of this branch of law. Thank you.